Hi everyone. My name is Alice Wanamaker, and I'm a legal scholar focusing on constitutional law and voting rights. My submission to Davidson Fellows is The Missing Right: Construction of an Affirmative Right to Vote, and it's a proposal of a constitutional amendment that would guarantee the affirmative right to vote to all citizens. I first became interested in this topic when I was studying for We the People, a high school constitutional debate competition. When preparing for that, I learned that the Constitution and Supreme Court don't currently grant all citizens the right to vote, which, compared to the approach that's taken with other important rights, like free speech, is really weird. We have a legal process for declaring fundamental rights, and a strict test used to analyze laws restricting those rights, but it's not used for voting, even though people in the United States rightly consider voting to be among our most important rights. The deeper I went into this topic, the more it felt like a puzzle. The Supreme Court has often ruled that disenfranchisement is constitutional because the actual text protecting suffrage in the Constitution is extremely limited. The thought exercise of puzzling out how to get around the arguments used in those rulings without leaving legal loopholes seemed intricate and exciting. I also wanted to prove that the right to vote could be protected through the strategic construction of an amendment, even considering those previous rulings I talked about. A philosophical theory that drove me towards that idea was political abolitionism, which Frederick Douglass wrote about in his newspaper. Political abolitionism suggests that the Constitution can be aggressively amended to actually protect equity for all people, sort of co-opting the philosophies used by the framers to have a broader, more ethical effect on the United States as a whole. This amendment is an example of how our existing government can be molded towards that goal. Now I'm going to explain why the right to vote is so important. My article includes two main arguments on this front, one more focused on theory and the other a bit more practical. So here I'm going to focus on the latter, which is political scientist Robert Dahl's idea of self-determination. The basic summary of self-determination is you best represent yourself in government. This means that one of the best ways to advocate for a demographic is guaranteeing their right to vote, so they can pressure politicians and participate in the political process. Historical examples of self-determination working include the fact that the first Black representatives in Congress were elected in the 1870s in the midst of the Reconstruction Amendment being passed, and the fact that public health and education outcomes in the South drastically improved in the 1920s after white women were enfranchised by the 19th Amendment. One group that could benefit from self-determination today is felons. Felons have a personal interest in reforming the criminal justice system, having it be fair and treat people humanely. Self-determination would argue that enfranchisement is a more effective strategy than just getting people with no personal connection to those issues to care about them. Another example of this is young people and the climate. My generation has a vested interest in solving climate change because we're going to be around to see its full long-term effects. So according to self-determination theory, allowing, say, 16-year-olds to vote on it might be a more effective strategy than trying to persuade other generations of how important it is. The people who are disenfranchised in the US right now are the people who most need to advocate for things. Black people, Native Americans, felons, and young people, to name a few. Giving them the ability to vote is a powerful way to support their needs. So my idea for this project began close to fully formed. It started when I sat up from watching TV and thought to myself, I want to write an article proposing an affirmative constitutional right to vote, and then immediately got up and wrote an outline for it. Broadly speaking, that outline stayed almost identical through the entire process. It originally included 5 sections, while the paper now has 4, but it introduced ideas in the same order. Why suffrage is important, how it's being limited and why those limitations are problematic, why the current law around the right to vote allows those limitations, and how my amendment would fix those problems. I diverged from this starting outline in the smaller bullet points I put, which were my initial brainstorming of evidence that could fit into those categories, because I found better examples as I researched. For example, abortion law wasn't the best choice to demonstrate self-determination, the things I talked about earlier were. And I also ended up not addressing gerrymandering, because the legal issues around it and the fixes that would be required have pretty much no overlap with the rest of the issues I studied, like felon disenfranchisement and voter ID laws. I was mentored by Diane Curtis, a professor of political science and legal studies at UMass Amherst. I originally asked her to check in with me 2 or 3 times as I wrote, and she countered with having us meet every week and giving me lots of feedback in between, to which I said, that's better, so then that's what we did. The most helpful part of her mentorship was showing me where there were holes in my argument so that I could fix them. It was my first major legal writing project, so I didn't always spot those holes for myself, but I was able to think my way through them and solidify my arguments with that help spotting them. In terms of the theorists and arguments I used in my research, most of what legal research is synthesizing and critiquing other people's work, whether it be the Supreme Court's reasoning or the opinions of other scholars. The full list of ideas I drew from is very long and is found in my article, but I'm going to go through the most used ones here. In the first section, there are two political theories I focused on to justify suffrage, which were 1, social contract and popular sovereignty. These have been studied by a lot of people, but I focused on arguments by John Locke, Akilah Marr, and Reba Siegel, and second, self-determination by Robert Dahl, which I spoke about earlier. Next, there's a number of cases that I consider because I'm thinking about jurisprudence and how the Supreme Court interprets writing around voting rights. Among the most interesting is Marion County v. Crawford, which is about voter ID laws and is probably the best illustration of the current problems I see with the legal protection of voting rights. A lot of research has been done on current disenfranchisement issues, so I read a lot of articles from many different sources. One major source was the Brennan Center, which has studied felon disenfranchisement extremely in depth, so data came from them in that area a lot. And then there were two proposals of other voting rights amendments that I focused on. One is called the Right to Vote Amendment, which was developed by Fair Vote and proposed in Congress in 2017. The other was proposed by Representative Jesse Jackson in 2003. So an immense amount of research has already been done on disenfranchisement and voting rights, and other proposals for amendments granting an affirmative right to vote already exist. My proposal is unique because when studying those other amendments, I found that a lot of them weren't written with the same strategy in mind as my proposal. I haven't found another amendment that's written with the specific intent of counteracting current legal doctrines that protect disenfranchisement. Here's an example. One of the other proposals I read said that it would grant the affirmative right to vote, except for laws that are narrowly tailored to protect election security. Now, I think it's totally reasonable to have laws that are narrowly tailored to protect election security, laws standardizing ballots or polling places, for example. Those restrict the right to vote, so like you can't vote on a napkin, but you still have to have them for elections to work. That exception should exist. But I didn't include it in the text of my amendment, and I didn't include it because the Supreme Court does that anyway. Even for the most strictly protected rights, they've always established exceptions. They use the strict scrutiny test, which states that laws restricting fundamental rights have to further a compelling state interest and be written in the least restrictive manner possible. The exception in the text of this amendment proposal seems logical, but it actually just creates a lower standard of scrutiny for exceptions to this rule than the court would create on their own. Now, that amendment was really carefully written, but it wasn't written with that legal scrutiny in mind. It was written to be presented logically to Congress and to citizens, who would want to make sure that election security was still protected. But in my mind, the most important audience for an amendment is the Supreme Court. My proposal was written specifically with the Supreme Court's theoretical interpretation of it in mind, and I haven't seen another one that's so specifically focused on that goal. One area that I didn't address in my research is the practicalities of the political climate. Some of these other amendments might have been written with political viability more in mind, considering that they make more sense to a lay audience. But I think that a politically viable amendment that doesn't actually solve the problems with current voting rights jurisprudence won't protect the right to vote. For that matter, neither will a strategically written amendment that never gets passed. So in my opinion, those steps need to be separated. I think what I've done is the first step, figuring out language that will actually be interpreted to protect the right to vote. Next comes figuring out how to get it passed. That second step determines my work's application. If it was ratified and became part of the Constitution, all this theorizing I've done about how it could potentially be interpreted by the Supreme Court would come to life. Felon disenfranchisement would be ruled unconstitutional, voter ID laws drastically restricted, and state election regulations would be closely scrutinized to ensure that they aren't more restrictive than is absolutely necessary. Overall, my hope in pursuing this project, which I think I've achieved, is creating a useful resource in the field of protecting voting rights. Even if my proposal isn't ratified, I think it's an important resource for the future of voting rights. It's a more strategic starting point than other proposals I've seen, and I hope that future researchers or politicians use it. It's also been incredibly fun and interesting to work on, and I hope to write voting rights legislation in a professional capacity in the future. Thank you so much for this opportunity.